Well, good afternoon to most of you joining us today. Good morning to some of you out on the West Coast. Thanks for joining us here at Fasken for today's presentation on Just Cause, What Employers Need to Know. This is one of our labor, employment, and human rights webinars, and a perfect topic for today, October 31st, probably the spookiest one we could put in front of you, maybe even the scariest one, trying to get to a just cause termination scenario. I'd like to draw your attention right now to a slide that we've got up. And before I introduce myself, you'll see some of our housekeeping items on the screen. I'd like to draw your attention to the fact that we'll be asking you to fill out a survey following today's presentation. We really value your feedback on today's presentation and any presentation that we give. And we encourage you to fill out the survey before you log off today. My name, though, is Marc Rodrigue. I'm a partner here in Fasken's Toronto office, a member of the Labor, Employment, and Human Rights Group. Like all of your presenters today, we do it all in the labor and employment side of things, whether it's union grievances, wrongful dismissal, civil actions, appearing before all levels of courts and arbitrators and boards. And it's my pleasure to introduce to you two of my colleagues. Louis Thomas Bélanger, an associate from our Montreal office, will be here today and will be focused in particular on some of the specific Quebec aspects of just cause termination, or what you'll hear is termination for good reason. And Rachel Counsell, my colleague and associate here in the Toronto office. Now, on to our presentation. I will say, too, you'll notice on your screen a place to put your questions. If any questions come up during our session today, please do put them in that Q&A session. We'll try to answer them as we move on. But if not, we'll do our best by the end of the presentation to answer them and encourage you to participate that way. We've got a pretty packed agenda for our hour and a half together. As you see on the slide right now, we'll talk about what we mean when we're talking about just cause. This will be a good refresher for some of us, how we might get there in terms of establishing just cause in a given scenario with an employee, a reminder about the importance of investigations where they are warranted, especially if we are going to assert we have grounds for a just cause termination, the idea behind progressive discipline around communicating a termination for just cause. And then we'll go through a fun exercise where we take you through some recent case law and allow you to decide, and please feel free to participate, as to whether or not you think we've hit the standard of just cause. Let's keep on moving forward. So, from the very beginning, what is just cause? A refresher. The courts have weighed in on this. The arbitrators have weighed in on this. I think it's common sense to many of you probably at this point in your careers. And if not, it will be very soon, that terminating the employment of an employee for just cause or for good reason is not only is it one of the more difficult things to do, but the courts and adjudicators consider it the capital punishment of employment and labor law. It applies on both sides, whether you're unionized or not. And you'll see in the Doppler Industries case, we get a good snippet of what we're talking about when we talk about just cause terminations. It really is a scenario in which the employee, consider this, it's the employee, not the employer, who is breaching the employment contract. And in order to do that, an employee has to go do something or commit an act or fail to commit an act, which goes to the root of the contract, the root of the relationship. And as a result of that conduct, the relationship is so fractured that objectively you could not continue it. Next slide. So why does it matter to us? Why we've got to hit this standard? Where is it going to come into play for us for the majority of scenarios? There are a few. For those of you who are unionized or dealing with unionized workforces, of course, absent certain conditions like a genuine restructuring or shuttering of business, you are permitted typically, depending on your collective agreement and any probationary periods usually, you are permitted only to terminate someone's employment where we've hit the standard of just cause for termination. Otherwise, we find ourselves in scenarios where individuals can be ordered back to work with potential back liability if we've mistakenly, and I'll use that term, terminated somebody without hitting our just cause standard. You'll also find the just cause standard used for those of you who are federally regulated in respect of the termination of employees who are non-managerial, who have accumulated as a level of seniority after a year, that they too have union-like protection for their job, and that if they are terminated without just cause, there is an opportunity for them to start a complaint, which could result in their reinstatement, much again like a unionized environment. We have some similar aspects that we'll talk about too. There are aspects in Nova Scotia, and we'll key in on some aspects in Quebec, which may result in similar style of protection for employee jobs and the requirement for us to hit what is essentially a form of just cause standard in order to uphold a termination. Of course, for those who are not unionized or not subject to any of these other job protections where we've got to hit a just cause standard, like at common law, there is an opportunity to terminate the employment of an employee if we hit the standard without having to pay reasonable notice, without having to pay severance in Ontario. Of course, we'll talk to some of the limits on that, Ontario in particular. And then, of course, on contract law, when we look at someone's contract, we may have some obligations or commitments in there if we hit a just cause standard. But obviously, when we are trying to get to this, we're trying to exit an individual without having any pay or liability going forward. Next slide. So let's take two examples for us, and Quebec's example is actually quite relevant for most of the country when we're talking about what does just cause mean if we're looking at statutes. Now, of course, statutes will come into play anytime we're looking to terminate somebody. If they've got a definition or they've got a common understanding, we have to abide by it. It may be different from the common law. It may be different from a contract. Quebec, again, like most provinces, doesn't actually have a definition of how we get to the standard. And so it takes guidance from previous law. It may take guidance from other provinces in determining what the standard is. In Ontario, though, and a lot of you who practice or have operations in Ontario have come to know this only too well, there is a defined standard for us to essentially get to a just cause for termination. And we find that under Ontario's Employment Standards Act. This is the only scenario in which, even if we are unionized, that we can terminate somebody's employment without any liability, without any requirement to pay. We mean notice or pay in lieu of notice or severance pay or any other termination entitlements that someone may have. And the standard we have to hit is not out there just defined by case law. It is willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. We already have some case law that says that is a separate standard than common law. So it is a higher standard in some respects. And so if ever we're looking to terminate somebody for just cause, we should be looking at this definition. We should be getting our legal advice to make sure that we've hit it. Otherwise, we may be faced with some consequences for failing to hit that standard. On to the next slide, please.
So as Marc has astutely alluded to so far in today's session, I think we all know by now that courts, adjudicators, and arbitrators will be very hesitant to find that an employer has just cause to terminate an employee without liability. And so what exactly does it take to establish just cause? It is important to remember here that a termination for cause is going to be an all or nothing proposition for the employee. The concept of near cause is not a doctrine that is recognized in Canada. So it's going to be a relatively rare situation where an employer can justify a for-cause termination absent a good investigation, supporting documentation, and a number of other factors. We are going to discuss today what you need to know about investigations and documentation. But generally speaking, an employer will need to show a clear-cut case to the decision maker on all of the evidence available of misconduct justifying cause for termination. And now let's look at that common law test a little bit closer. As Marc mentioned, recall that the standard for just cause at common law may differ from the standard that we are applying under particular employment standards legislation, like in Ontario. But for the purposes of this section, we're going to be talking about the common law standard that typically applies. Now, the test for just cause is derived from the Supreme Court of Canada's case in McKinley and BC Tel. Essentially, the key question is whether the employee's misconduct has given rise to a breakdown in the employment relationship. Now, this is going to be an objective test seen from the perspective of a reasonable employer who is taking into account all of the relevant circumstances. Now, the case law in Ontario has outlined a three-step analysis that breaks this down a little bit more for us. First, the court is going to determine the nature and extent of the misconduct. Second, we will consider the particular circumstances of the employee within the employee relationship. So, for instance, when we're thinking about the circumstances of the employee, one might consider factors like the employee's age, their employment history, their seniority, their roles and responsibilities. With respect to the employer, one might consider factors such as the type of business or the activity in which the employer is engaged, the relevant policies and practices that you have in your workplace, the employee's position within the organization, particularly if they are a member of management, and the degree of trust that the employer places with the employee as it relates to their role. The context is also going to involve a consideration of mitigating and aggravating factors, which I will touch upon in a second. But the third part of this analysis is a determination, ultimately, of whether the dismissal for cause is warranted, and whether, more specifically, the dismissal is a proportionate response to the misconduct. In McKinley, the Supreme Court of Canada was very clear that a contextual approach must be taken when examining if an employer has cause for termination. So there is no one-size-fits-all. There is no particular ground of conduct that is going to warrant termination in all of the circumstances. The purpose of the contextual analysis is to determine whether the misconduct has led to a breakdown in the employment relationship or is otherwise irreconcilable with the continuation of that relationship. The key word that we are going to focus on today is the term of and the principle of proportionality. An employer's sanction for any type of misconduct or poor performance must, in a decision maker's view, always be proportionate. Next slide, please. As we discussed earlier, this onus is on the employer to establish that it had cause to terminate. Generally, the employer needs to show on a balance of probabilities, so it is more likely than not that the employee's conduct fundamentally damaged the employment relationship. This being said, where the misconduct would also constitute something that arises to the level of criminal activity like theft or fraud, the standard of proof is going to be higher. Decision makers will want to see clear and convincing evidence that the misconduct occurred. Of course, in our line of work, ideally, you would always want to see clear and convincing evidence in all cases when you're issuing discipline, even where the activity isn't close to criminal, and particularly where it involves weighing credibility between multiple versions of events or different witness evidence. In all of these cases, determining whether an employer has established just cause is a balancing act. We see many times that an employer will want to get rid of an employee after one or more incidents of poor performance or inappropriate conduct, and for very good reasons. However, it may be necessary to recognize that, as frustrating as it may be, the documentary trail and the evidence just isn't enough to justify a termination for cause. We've seen many situations come across our desks where an employee's performance is bad, or they have conducted something, they've behaved unprofessionally or inappropriately, but it is just not serious enough to meet the very high threshold of establishing just cause. In these circumstances, it's important to recognize that there are risks to terminating for cause, because when it's an all or nothing proposition, it's fairly likely that an employee will bring a claim for wrongful dismissal, or in the union context, a grievance challenging their dismissal. This will lead to legal fees, potentially damages, costs being awarded against an employer if they are ultimately unsuccessful, or reinstatement potentially for unionized, federally regulated, or Quebec employees. And so employers should consider, when they're making these determinations, the time that it will take to build a case justifying a termination for cause, as well as the potential costs of any future litigation. As a quick note here, in response to one of the questions that we received in advance of this session, I wanted to note that termination for just cause is usually based on the information an employer had prior to deciding to dismiss an employee. But what happens if information comes to light after an employee has been let go without cause, which the employer says would have substantiated cause for dismissal? Well, a defense for after acquired cause is available when the employer discovers information after a dismissal that, if they discovered it during the employment relationship, would have justified a termination for cause. This defense must be based on information discovered after the dismissal, which the employer was unaware of during the employee's tenure. And so there's also going to be risk associated with asserting after acquired cause based on information about misconduct that an employer had or ought to have had prior to the dismissal and may have just condoned. So we've talked about the standard for establishing just cause. What are the different grounds for which an employer can terminate? We're going to discuss some concrete examples from the case law later on in today's session, which I think will be more illustrative for our purposes. But for now, you'll see on the screen a range of the different grounds that could justify a termination for cause. It spans from deliberate, nearly criminal misconduct to simply repeated poor performance. And many of these grounds are self-explanatory, but we sometimes get questions about what constitutes, for instance, insubordination, or what kind of dishonesty justifies a cause for dismissal. In brief, when it comes to dishonesty, just cause can exist where the dishonesty violates an essential condition of the employment contract or is fundamentally inconsistent with the employee's obligations to their employer. And so this is where concepts like breach of trust can come into play. With respect to insubordination, an employee's willful disobedience on a serious or important matter may amount to just cause for dismissal as well. The employer will need to prove a number of things in order to justify termination for insubordination, including that the order that the employee disregarded was clear, specific, reasonable, lawful, within the scope of the employee's duties and responsibilities, and the employee's disobedience was deliberate or intentional. Finally, what about poor performance? Well, in order to terminate for cause for an alleged failure to meet performance standards, an employer needs to show that they have first established reasonable and objective standards of performance. We'll be touching upon this later in our progressive discipline section. We'll also need to show that the employee has failed to meet those standards, that the employee has had warning that their employment is in jeopardy if they do not meet the standards, and the employee was provided with reasonable time to correct the situation. So just a mere failure to meet performance standards is not necessarily going to be enough to terminate for cause. Of course, and as we'll talk about later as well, while this standard of incompetence is going to be high, it will be easier for employers to meet this threshold where there have been many warnings and previous progressive discipline on the employee's performance. On the flip side, an employer who has condoned an inadequate level of performance throughout their tenure may not later be able to rely on all of that behavior as a ground for dismissal. And so again, just underscoring the importance of progressive discipline when it comes to incompetence-related issues. Finally, we want to recall that when in that third step of the analysis, assessing whether the termination is a proportionate response, employers are going to need to consider mitigating factors like long service, a clean disciplinary record, and whether or not the employee has taken accountability for the misconduct, as well as aggravating factors, including a lack of remorse, a lack of accountability, and any disciplinary history. Think about things that are relevant to the situation in addition to contextual factors we talked about before, like the employee's seniority and their role. As you'll see in our case law examples later on, courts pay attention to these contextual factors in determining whether an employer was justified. And finally, I just wanted to note very quickly, as you all already know, as is the case with any other employment-related decision or terminations without cause, employers cannot terminate employment for reasons related to any protected grounds under provincial or federal human rights legislation. I won't belabor the point, but what becomes tricky is where an employer may have many legitimate reasons for terminating an employment for cause, but still needs to investigate whether or not any of those factors are tied to a protected ground. Next slide, please.
All right. So as Rachel said, actually, the burden of proving just cause, or for Quebec, good and sufficient cause, is on the employer's shoulders, which means basically that one of the key factors when you want to proceed with a termination will be investigating and documenting the situation. What we will often say to clients is when you're deciding to proceed with the termination for just cause, you will probably be preparing for a challenge and for a dispute. So you want to make sure that your file is complete. Next slide, please. The image actually on the screen right now really represents well the situation. So what is stated there is just because you did it doesn't mean you're guilty. Basically, the employer will still have to prove, as Rachel said, with the appropriate burden, that the employee has actually committed the fault that is reproached to them. So it's important for employers basically to remember that the investigation has to be conducted and has to be properly conducted. This means that basically without an investigation, an employer would, possibly expose themselves to various risks. One of them being not having respected the procedural fairness that is requested and required for employers when they want to proceed with the termination of employment. One of the other factors that is important to remember there is that if you want to proceed with the termination and you have not proceeded with the appropriate investigation, you may simply not have enough evidence to proceed or to have the measure that's been taken upheld by an arbitration tribunal or by any type of tribunal that will hear the dispute or hear the case. In Quebec, this could mean that you would be entitled to reinstating the employee, for example, or that you could be entitled to paying various damages or indemnities to the employee that's been dismissed. So basically, it has to be remembered by employers that when you want to proceed with the termination of employment, you have to make sure that you're building your case properly and that you're documenting the file really properly to avoid any type of risk. Next slide, please. So once a potential misconduct has been identified, employers will basically ask themselves, now what do we do? How do we proceed with the investigation? That is the main question here, and it will depend on various factors. One of them being the gravity of the fault that is reported. What you will want to do basically before imposing any type of measure, it could be the dismissal determination for cause of the employment, but it could be also a suspension or a notice. Basically, you will want to proceed with an investigation, which would include meeting with the relevant witnesses, using the tools that the employer has to ensure that the fault has really been committed. We want to avoid risks, as stated before, and we want to make sure that the procedural fairness is actually respected, which means that the employee has been able to explain the situation to the employer, that the employer knows the facts, and as I said before, the employer feels like it has a solid enough file that can be presented before the tribunal to prove with the appropriate documents or exhibits or proof that the situation has actually happened. So basically, you will want also to make sure that you're acting consistent with past practice, that the sanction that is being imposed is not disproportionate with respect to what has been applied in the past, and also that you're timely. The timing is basically key as along with the investigation, because, well, first of all, in unionized scenarios, there could be delays in the collective agreements by which an investigation has to be conducted, and if you're not in a unionized environment, there still is a key element to proceed with a timely investigation, because first of all, you will send a message to the employee if you take too much time to proceed with the investigation, meaning that the employee might feel like you don't think like you have a strong enough file to proceed with determination. And basically, second of all, the arbitrator or the tribunal will also feel like the investigation might have been conducted in bad faith or as a retaliation for something else committed by the employee during the performance of the work. So basically, the employer will want, before proceeding with determination, to prepare for a proper investigation and to conduct the investigation, keeping in mind that they will want to make sure that they know everything surrounding the circumstances of the file. Everything is a question of circumstances, basically, in employment law, and especially this is especially true with respect to termination. Rachel spoke about aggravating or mitigating circumstances. This is one of the things also that the employer will want to confirm with the investigation. So there might be scenarios where you feel as an employer like you're taking the right decision at the right time. If, let's say, theft has been reported in the workplace, but should a proper investigation be conducted, the employer might learn that there are various mitigating circumstances that would have brought the employer to take another decision, or at the opposite, if the employer feels like they want to proceed with a immediate suspension, disciplinary suspension, not investigation suspension, but they decide to, at the opposite, proceed with the proper investigation, and that they learn that there are various aggravating circumstances, then they might want to actually proceed on to the next step and proceed with determination. So basically, what has to be remembered here is to always proceed with the right investigation. Next slide, please. As an example, actually, for employers, there's a case that proceeded in Quebec a few years ago. It's dated 2015, but the principles are really still applicable here. It's the HY Canada Inc. case. It was brought before the arbitration tribunal in Quebec, and basically it's the case of a waiter in the hotel industry that was dismissed because he allegedly stole money from the cash register of its employer and failed to follow the cash out procedure. The employer took a preliminary decision, basically to dismiss immediately the employee. It's a decision that was taken out of emotion because the employer felt like the employee had, committed theft, and basically the employee challenged the dismissal, as is often the case in such scenarios, and claimed in its defense that basically he had intended to return the money to the employer but did not have the time to do so, and he basically had been dismissed in the middle of the next shift. The money was still in the workplace. So what we have to remember here is that the employee, basically what he did at the end of the shift was he took the money from the cashier, put it in an envelope, noted the date on the envelope as well as the amount that had been put in the envelope, and put it in its locker. There was no investigation conducted by the employer, and immediate termination was imposed on the employee without any sort of investigation. And basically what happened, no surprise there, was that the termination was annulled by the tribunal. And what the tribunal said was, because of the failure to investigate, well, first of all, the employer did not have any sort of proof to submit to the tribunal regarding the theft. As I stated before, and as Rachel and Marc stated before, the burden of proof is on the employer's shoulders there, and the employer was not able to provide a proof regarding the intention to steal. And the arbitrator actually said that should the employer have investigated, he probably would have learned that the employee intended to return the money to the employer. It was basically a fault because the employee did not follow the procedure, but it was not a fault that was grave enough to entitle for the termination of employment. So what this example says to the employers is, if you don't proceed with the proper investigation, there are various risks to proceed with the termination. And at the opposite, and I will talk about this a bit later, if you conduct a really good and thorough investigation, a case that at first might not have seemed too solid might, with circumstantial evidence, become really solid. So basically, just remember, lots of risks of proceeding without investigation and proceeding based on emotions, basically. And at the opposite, good and thorough investigation will lead to good decisions. So we can go on to the next slide. This is a little timeline there, a little reminder for employers on how they should proceed with the termination. So basically, once an employer receives an incident report or a complaint stating that a fault has been committed in the workplace, the first step that they should do is plan for the investigation. Rachel said earlier that, depending on the gravity of the fault, the burden could be a bit more difficult to fulfill for an employer. So this is why we really have to plan for the investigation, knowing what we know, what we will be able to prove. So plan. This is we cannot state this enough, but basically the employers should make sure that they know who they want to meet, what type of fault was committed. If they want to have maybe external help, this is something that we will often do in cases of harassment, because procedure states that normally an investigation should be conducted impartially. Sometimes if you have a smaller work group or people are just maybe too close, depending on the scenarios, outside help, outside counsel could be the way. So basically, we want to plan for the investigation, and then we want to conduct the investigation. What we will want to do with conducting the investigation, I've said it before, but I'll say it again, is make sure that the plaintiff or not the plaintiff yet, but the person that is being investigated has the opportunity to express themselves. We will make sure that we learn if there are aggravating circumstances or mitigating circumstances. If I can give an example to employers, sometimes we will want to have the employee give its version of events, because they will maybe express at this point some mitigating circumstances as addiction. If the employee does not speak during the investigation meeting, usually in Quebec this is the case, the arbitrator will consider that it's basically too late for the employee at the hearing to say that they have addiction. So this is another thing there. We want to make sure that we document that we have given the employee the chance to express themselves, and then we take the decision. So depending on how strong we feel about the case, and we cannot recommend this enough. Maybe sometimes if we feel like the scenario is not perfect, get outside counsel on what the decision should be. But basically, once the investigation is over and we feel like we've reached a decision, then we can decide whether we want to impose termination or whether we want to go with another type of measure. And finally, basically just documenting the investigation as much as we can, because as I said, we are actually preparing for a trial potentially. In Quebec, this is very often the case in unionized scenarios, or whether we're in a non-unionized environment, but the employee has reached 2 years of service, there will be a right to dispute the decision. So this is really important to have the documentation or notes being put in the file for further use. Next slide, please. There's something there that is really interesting on the screen right now, is basically which document could be used as evidence for the trial, or for documenting the file. Depending on which type of scenario, which fault has been committed, personal files, time cards, especially for time theft, emails, electronic files, medical files, expense files, work files, and policies and acknowledgements of the policies will be very useful. These elements are very standard in the scenario of a dispute on just cause or good or sufficient cause in Quebec. There are also other means to basically document a file. This could be, actually looking into the property of the employer. We could have desks, lockers. This is especially true with drug-related cases. There's a case in Quebec a few years ago that preceded, where the employer basically had reasonable doubt that an employee was selling drugs at the workplace, and basically decided that they would investigate, and they would proceed to opening up the employees' lockers. These sorts of investigations, sometimes entitled, or they will bring charter questions, depending on the right to privacy. But these, if they are executed in the right way, can make or break with a termination case. So if you have reasonable doubts, usually, and we recommend consulting your lawyer here at Fasken, but you will be entitled to, let's say, opening up a locker and just validating if you have evidence in there. There's workers' compensation files that could be used to, criminal records or transcripts, drug and alcohol testing, camera videos, social medias, as well as text messages that can be very useful to document a file. This should be part of the investigation process, so it should not necessarily be taken or be saved after the decision. Depending, of course, if the evidence is still available, there could be a way to complement the case, but usually we will want to know the information before taking the decision, which means we want to plan and integrate this into the process. Next slide, please. So as far as the results go, as I said, we will once we've conducted the investigation, we will want to determine whether we want to discipline and at what level. We will want to explain the employer's position to the employee, which I will talk about a bit later in the presentation. And we will want to make sure that we are ready to defend the employer's position before a tribunal. So these are the main elements on why we want to investigate properly, especially because we want to be able to justify the decision and fulfill the burden of proof. So basically, we can go into the next slide, and I will let Marc explain what progressive discipline means.
Yeah, just before I start into progressive discipline, I just want to pick up on a key point that Louis has made. There, and it comes on the heels of a case just getting published yesterday, October 30th. That is a reminder that if we investigate, we have to do so thoroughly in the circumstances. The case dealt with a railway worker who allegedly made some comments that the employer ultimately used to justify termination for cause in a unionized environment. And the proof, essentially, that the employer had was that an employee who had overheard the comments sent an email in explaining what the comments were. Now, during the course, there were other issues, of course, there always are, but during the course of the investigation, the aggrievor here said they never made the comments, in fact. And what the employer neglected to do was to follow up with the author of the email, to ask them to make a statement, to follow up on the comments, to actually investigate what they had to say and had put in the email. And instead, the employer relied on the email. And the employer said to an arbitrator down the line, don't take the evidence from the grievor that he never said it. You should agree with us that the email is sufficient proof that he did say what he said, what we say he said. And though he may have said it, right, and though that may have hit the just cause standard, the arbitrator said, in what world am I to accept an email over the word of somebody, saying directly they didn't say it? You've got conflicting evidence, and you did not properly investigate. Had you gone to talk to the author of the email and come up with a sufficient ground to say you agree with them, maybe I would have agreed with you. But you shortcutted your investigation. Therefore, there is no just cause for dismissal. You haven't proved it. It's on you to prove it. You haven't proved it. Therefore, the person comes back to work. So let's continue on with progressive discipline and talk a little bit about the principles that will apply ultimately and often in a unionized workplace where we are typically required to follow a progressive discipline path if somebody has taken steps which are contrary to expectation or contrary to the collective agreement, where the punishment gets more severe before we get to a just cause termination. And this may also, in the course of a non-unionized environment, be something that we also follow. Not every infraction is going to get us to cause for termination. And in fact, we may want to have what I'll call some water behind the dam before we get to a just cause scenario, especially since not every scenario of just cause is going to be a grand event or circumstance where we say we can fire somebody immediately. Those do come up, of course. Rachel spoke to some instances where they may come up immediately, whether you're in a unionized environment or not. But oftentimes it's not so clear cut, and we have to continue to discipline and coach and record where we're having infractions, and we want that on the record where we might get to just cause over time. Next slide, please. Again, when we are talking about progressive discipline and we're holding people to standards of performance or policy, there are certain touchstones that we're going to have to defend in case we're ever challenged, especially after a termination. We have to establish, of course, that whatever the policy or expectation we had on an employee was clear and was reasonable. Right? It's a reasonable standard for us to want this type of performance or adherence to this type of policy. And it's clear to the employee would understand it, the adjudicator would understand it. We haven't hidden policies. Yeah. And in most cases, you'll hear us tell you it's even better if you can make sure that employees know the policies, have read the policies, have been educated on the policies, have signed off on the policies. So they can't say, I never even knew I had to do this, and now I'm being disciplined for it. Now, there's also a requirement on us to show that we are consistently enforcing the policy. This is especially if we're letting everybody get away with something, and then all of a sudden we want to hold somebody to a policy or an expectation, and they're the first one that gets sort of picked on and can raise that they've seen a million people do it in front of our managers or supervisors, and all of a sudden they're the target. Now, in that case, they can simply rely on the fact that we've condoned this type of behavior, and they thought it was okay. Again, we lack clarity. And then, of course, when we talk about progressive discipline, although for all of us who are involved in issuing it, usually there is a punitive aspect. In theory, progressive discipline is about giving somebody another chance. Right, is about having consequences for actions, but giving somebody another chance in terms of correcting the action and not happening again. And I know for all of us, That's always the hope, that an instance of corrective action will solve it, and we won't ever get to the cause for dismissal standard. Next slide, please. So on your screen now, you'll see the progressive discipline path. This is the typical path we'd follow, especially in a unionized environment. You'll see there's suspensions here. In a non-union environment, use of suspensions has to be done very cautiously. There will be circumstances, indeed it's the default if you're non-union, that if you issue a suspension, particularly an unpaid suspension to an employee, that could be constructive dismissal. In the unionized environment, we have more tools at our disposal, including potentially unpaid suspensions. So let's consider this as a union template, and more so union than non-union, but verbal warnings would apply union, non-union, to issue somebody a verbal warning. If ever you do that, remember to make a note somewhere, to record it. Coming to a judge down the line and saying, oh, I think I issued a verbal warning 5 years ago, without any record of that, is a far worse scenario to put yourself in than saying, hey, I issued a verbal warning on October 31st, 2023. I know I did it because I created a note as soon as I did it. I have a clear proof that this happened. So make sure that you record it, even though we're only telling the person verbally. Obviously, a written warning, again, union and non-union, that can be in there. What we want to make sure we're making clear to everybody that is issued a written warning, whether they're union or non-union, is that if they continue on, the discipline could get more severe. In a union environment, again, be careful doing this in non-union, as suspension is usually next. It might be a 1 day, progressing then to a 3 day, progressing then to a 5 day. You want to check your collective agreement and past practice in the unionized environment, and make sure once we're getting to the more significant suspensions, we're being very clear that this is it. Anything more might lead to termination of employment, or this is the last step. In a non-union environment, if we're issuing a verbal warning and then a few written warnings, eventually we want to make it clear, if this continues, you are on the path to a dismissal. We want to make sure that we have put the employee on notice. And the reason for that is that you will be expected to have given the employee a chance to correct themselves. And then finally, of course, if we think we've done everything absolutely right, or we're close enough, we may be looking at a termination of employment scenario where it's a cause termination. Again, as you've heard already, everything is so fact dependent on what have we done, what have they done, what got us to here. We could have gone through a whole set of progressive discipline, which have serious action, serious action, serious action. And then the latest action might be something that we look at it and we think it's not as serious or so serious, right? They're, 5 minutes late. And in the last few, issues, they've been no call, no show, no call, no show, told that this is the last chance, but 5 minutes late. Is that enough for us to say we think we've got this on a cause dismissal? We've got to be cautious, even in those circumstances, to look at what has just happened in the scenario. So why don't we go on to the next slide? Looking at this set, again, mainly picking our options from a unionized environment here with suspensions being included. We've got a few scenarios, like Larry misses a day of work and does not call in to explain why. Now, if that's the only fact we have, what do we think is the most appropriate set of progressive discipline? Say we probably are on the left-hand side, the lighter discipline, the coaching, the verbal warnings maybe. But what if in this scenario, this is, the 15th day in 30 that Larry has done this? Well, we may be past those, or we may be, already up to written warnings. We may already be up to suspensions. It all depends on what the facts are. Same thing, Greg corners Martha in the hallway, purposely brushes against her inappropriately. You're going to want to, of course, get a good investigation done there. And it may depend on what our, at the end of the day, our conclusions are on the evidence. If we are, solidly believe there is some sexual harassment going on here, and we have zero tolerance, and we've got all the policies in place that we need, maybe it is termination. Maybe it is a significant suspension. Maybe we're skipping coaching, verbal warning, written warning all the way. It depends on the facts. Same thing, Lucinda makes the same reporting error 3 times, been coached for the same problem twice already. Again, we are looking at somebody maybe who's got a clean record other than the coaching. So what's next? What is the error? Is it a big deal? Is it a small deal? What have we told her about what happens next? Maybe it's a verbal warning, maybe it's a written warning, but we want to make sure that we're tailoring it to what has happened, the severity, and what we've done about it in past. Next slide, please. Okay. Now, again, progressive discipline, in large measure, this is what we're, faced with, unless we've got that big ticket item, that big moment or circumstance, which we say we can skip all the rest. This is a termination scenario. So if there is serious misconduct that meets that critical standard that we think this has undermined the employment relationship, this is the employee breaching their employment relationship, and there is no way to save this, then we may just skip right to the tail end. And we may assert that we have just cause for termination. With management employees, and I know somebody has asked about this, does the level of the level of action depend on the level of the employee? And the answer is it may, right? There are some employees who we rely on to set the example. So if I have a manager who is falsifying documents, or somebody who is higher up in the company in a position of trust, or even more so in a fiduciary position to the company, the scenario in which I might jump to cause for dismissal might be a lot sooner than somebody who is low level, right? Who is being observed, who we should have caught earlier on. The same may be said of individuals who work independently or who work in certain industries. I can think of, for example, that there's case law out there involving people in financial services, right? And the courts have rightfully indicated that if somebody is working in financial services, working with clients, working with their money, working in a position where they can easily manipulate things and put others at risk, including the bank and all of the folks who have entrusted the bank with their funds, then that person may be held to a higher standard of accountability, right? Than perhaps somebody working at the front desk of a major office building, but who is simply answering phone calls and taking in petty cash. There may be different standards here, again, because we fundamentally need to have trust as a working public, as an employer, and people in these positions where they can operate independently with significant risk power. The same thing may be said also, let's just point out zero tolerance policies. And now we call them zero tolerance policies. But again, like I say, it still has to hit the standard. We can have as many zero tolerance policies on anything you want. When somebody breaches a zero tolerance policy, you still have to look at the facts to decide whether or not we've got just cause for dismissal, or we've hit the standard where we're not going to owe anyone anything for dismissal, or we can terminate their employment under a unionized environment or where they have that protection. So, zero tolerance policies are here. Again, it really depends what they are and what the fact scenario is. Next slide, please.
All right, so time is flying, but I want to address the communication of the termination, which is basically a reminder for most employers, but it's generally admitted and recognized that if you want to proceed with the termination, there should be a meeting where the decision will be given to the employee, as well as a letter confirming the decision itself. So this is something that has to do with the law. So some provinces, I don't know about all of them, but in Quebec it has to be in writing. I believe in Ontario too. Marc or Rachel, correct me if I'm wrong. This has to do with this. This has to do also with procedural fairness, as well as many collective agreements, which will give some obligations to the employers as far as what has to be included in the letter. So next slide, please. What we will want to do basically with the letter is have it individually addressed to the employee, having it clear and unambiguous with respect to the termination date, delivered through permitted methods. For Quebec, there's no specific method. However, if there's a in-person meeting, we generally recommend employers to give it by hand and send it by email afterwards, so that the employee cannot basically allege that he or she has never received the letter, it shouldn't identify just cause and specific grounds. This is especially true, as I said before, in unionized environments where the agreement might have some specific obligations with respect to facts or motives that should be included in the letter. It should set out the disciplinary record if it's applicable, and basically if the termination it is for one serious, only one, but one very serious fault, this should be indicated in there, and address any other pertinent matters with respect to confidentiality, return of the company property, the benefits, record of employment that should be emitted after the termination, etc., etc. So basically what we want to do, and this is, this goes along with what I said previously, meaning we're preparing potentially for a termination or a dispute. We want to make sure that the letter is very clear as to why the employer has taken its decision, and basically why this constitutes serious fault. We can go on to the next slide, please. As far as the meeting will go, there's a few recommendations to give to employers. First, it's the appropriate time. What we will recommend there usually to employers is to choose the right time to avoid any disruptions on production or any crisis that could occur, during the workday. So normally, a termination should be done either at the beginning or the end of the workday. Also, there's the fact that the employee might have to, collect his personal items at the workplace, and we want to make sure that there's the least disruptions as possible. That's why we would also favor a private location without disruptions, just to make sure that there are no problems there. As far as attendees goes, this is especially true with unionized employers, but you will want to make sure that all the dispositions of the collective agreement are respected. It means that if the employee has the right to have a representative of the union with them, then they should be informed of that. As far as witnesses go, this is also true for the employer. Sometimes you're in a situation that is, or in a case that is so delicate or that is so complicated that you will want to make sure to have a witness that could be there, so that we can further document the file. We might, in some scenarios, want to have security. This is not usually the case, but I could see this, being necessary in a scenario where we feel like the employee who's committed the fault related to violence might resort to it again. It's something that could be happening. It's not very common, but you want to make sure when you plan for this meeting too, this is something that's been stated along during this presentation, but the planning is going to be key there. And even for the attendees at the termination meeting, we want to make sure that we've evaluated the solutions properly. One last recommendation for employers is on how to conduct the meeting. If some of the HR personnel in charge of the meeting have not been doing this for a long time, or do not feel necessarily really comfortable with doing this on the fly, there's also always in the preparation. There can be a preparation, but maybe of a script. But what we really want to make sure to provide to the employee is the information, actually communicating the termination first, so that they don't feel like there's an option where the decision could be annulled during the meeting, or that there's some hope of re-employment. So we want to be really, really clear on why we've taken the decision. We want to avoid small talk, because sometimes if the employer goes into small talk, into details, this might lead to disruption. This might lead to the employee thinking that they have a shot at maybe disrupting the workplace or having the decision annulled. So what my recommendation for employers is communicating termination right away, provide a copy of the termination letter, sticking to the information that is in the termination letter. We don't want to send a confusing message to the employee during this meeting and basically avoid, as I said, providing false hope of re-employment. So we want to be really clear. We want to be as brief as possible, but not too brief so that the employee feels like they have not had a proper explanation. And we want to provide the letter at the time of the meeting. And I would recommend also basically sending it either by email or mail, depending on, which type of work environment we're at, but just making sure that the employee cannot state that he or she has never been informed of the content of the letter. So next slide, please. With respect to post-termination, again, we will want to allow the employee to gather the personal items, i.e. the fact that we want to, choose the right timing for the meeting. We will want to escort employee off premises, make sure that they are leaving after, since they are not employed anymore by the employer, address the company property, as I said in the meeting, take notes. This is really important. Sometimes the employee will have a reaction during the termination meeting. We want to take notes, we want to document, and then we will want to inform, the others as well as the payroll. For the payroll, usually, we will want to make sure that on the next pay, any sums that are owed, for time worked or vacation will have to be paid. The record of employment will be omitted with the right coding, and then we can consider basically that the termination has been imposed on the employee. Of course, there's various delays for contesting or disputing the measure. So basically what the next step would be for the employer is waiting to see if the employee has decided to challenge the decision, and where we feel like the letter was clear enough and the decision was strong enough, then we can start maybe preparing for trial. Next slide, please.
So being mindful of time, we are going to do a whirlwind of some recent case law updates to give all of you folks a concrete capture of what these cases look like on the ground, and put our analytical framework that we discussed today to some work. Next slide, please. So the cases that we will discuss are going to touch on issues of harassment, of drug possession in the workplace, poor performance, theft and time theft, as well as the interesting question of off-duty misconduct. Next slide, please. So the first case I wanted to touch upon is Render, a recent Ontario Court of Appeal decision. Now, the employee in this case had worked for the employer for 30 years, most recently in a management role. It's notable that it was a very social work environment at this particular workplace, where unfortunately inappropriate jokes and banter had been very much accepted as the norm. That being said, the employer had instituted an anti-harassment and anti-discrimination policy that was zero tolerance for harassment and discrimination. The incident involving this employee occurred one day when he slapped a female colleague on the buttocks and later joked about the incident with some male colleagues. That female colleague reported the incident to Human Resources, and the employer conducted an investigation, ultimately terminating the employee for just cause. At trial, the trial judge found that there was just cause to terminate the employee, even though it was one incident. The trial judge considered the sexual nature of the conduct, the employee's lack of appreciation of the severity of the conduct as demonstrated by his comments following the incident, and the fact that, as Marc mentioned earlier, the employee was a manager and responsible for implementing the employer's anti-harassment and anti-discrimination policy. So these factors outweighed the fact that the employee had a long and unblemished disciplinary history with the company, And ultimately, the trial judge found that the employer had terminated the employee for cause and was justified in doing so. Next slide, please. The Ontario Court of Appeal upheld the trial judge's ruling. And just a couple comments I wanted to point out here from the Court of Appeal's decision. Specifically, the court commented that the employer's type of workplace where this kind of inappropriate banter was the norm, quote, could no longer be tolerated. And that kind of workplace atmosphere could not be condoned. And so the employee's termination for cause was justified, particularly because he was in a management position. I will also note here that for the purposes of Ontario employees, the Court of Appeal here concluded that the employee's misconduct had not actually arisen to the standard of willful misconduct because it had not been pre-planned and was determined to be in the quote-unquote heat of the moment. And so while it wasn't accidental conduct, it also was not premeditated. And so this employee, in these specific circumstances, was still entitled to his statutory minimum entitlements under the Employment Standards Act in Ontario. So this case is a great demonstration that a single incident can be enough to establish termination for cause, especially where it involves sexual harassment or sexual misconduct that clearly cannot be condoned in the work environment. Next slide, please. So the next case is an example of the increasing severity with which employers are treating racially motivated conduct as well. It highlights that times have changed and incidents of racially motivated behavior in environments like today's climate will no longer be considered shop talk or a one-off incident, but could very well justify a termination for cause. So this is an Ontario 2020 arbitration decision involving a verbal altercation that broke out on the floor of a clothing distribution center between two unionized coworkers. A white employee had aggressively directed racial slurs towards his Black coworker, and the incident was witnessed by several racially and ethnically diverse employees. Following an investigation, the company found that the employee's conduct had violated the company's workplace violence and harassment policies, and the employer terminated the employee for cause. The union challenged the termination, and one of the arguments that the union made was that even if the alleged conduct had occurred as alleged, it would have amounted to shop talk rather than egregious workplace harassment, particularly in light of the griever's 23 years of service and otherwise clean disciplinary record. The arbitrator upheld the termination for cause, referencing the evolving social and political climate and the push to eliminate workplace harassment. The arbitrator found that the conduct was sufficiently serious to attract termination, and that it was supported by the fact that the incident was overheard and that the employee denied his wrongdoing and didn't apologize or demonstrate genuine remorse. And so the fact that the employee's actions were an attack on his coworker and were an affront to the company's diverse workforce as a whole played a role in this decision. Next slide, please. So pivoting slightly to discuss a case about drug possession in the workplace. This is an interesting case that involved a very specific type of safety-sensitive workplace, particularly an offshore petroleum production platform. So in this case, the griever was employed as a millwright on a call-in basis on this petroleum production platform. He was terminated for non-compliance with the employer drug and alcohol policy after a small amount of marijuana was found in the pocket of his jeans during a screening before he boarded a helicopter to transport him to the offshore platform. Again, this was an instance where the employer had a zero tolerance policy prohibiting the possession of illegal drugs at a time when marijuana was an illegal drug. The griever did not dispute that the marijuana was in his possession, but argued that he just didn't know how it got in his pocket. At arbitration, the arbitrator accepted that the employer had just cause to terminate, stating that the griever had not offered an alternative explanation as to how the marijuana got into his pocket. The arbitrator also took notice of the fact that the platform was dangerous and had strictly controlled access in a very safety-sensitive environment. And in a lot of these drug and alcohol cases, that is going to be a key consideration. So the safety of the workplace was paramount, and the deterrence of others from possession was necessary to justify the termination. On judicial review at the Supreme Court of Newfoundland and Labrador, the judge set aside the arbitrator's decision on the basis that it was unreasonable, but then, next slide please, the arbitrator's decision was restored at the Court of Appeal, and the Court of Appeal found that the arbitrator's decision was in fact reasonable. And so the takeaway for this decision is really that policies may strictly prohibit drug possession and authorize disciplinary action, but it is going to be very much dependent on whether the workplace is a safety-sensitive workplace.
Okay, let's turn briefly to cases involving inadequate performance. And I know that we talked about that a little bit, about inabilities to do the job or poor performance. I know that some of you have put in questions about using performance improvement plans and the like. Before I talked about this case, I just wanted to mention that I do always think that using performance improvement plans and clearly communicating to employees what expectations are of job performance is never a bad thing. Keeping aside us talking about just cause dismissal grounds. Now, for all of us, I think, if we're considering inadequate performance or poor performance as grounds to look at termination of employment, at least for cause or hitting that standard, it is one of the most difficult standards to get. I think we should be clear on that. And it's one which ultimately may require you to prove a level of sort of gross incompetence to get there. We've mentioned it at the top end that adjudicators, judges, know how losing one's job can affect an employee, especially losing it for performance issues or for, little issues here and there. It can be very difficult to convince an adjudicator that someone should lose their job with no recourse for that, even if we've gone through performance improvement plans and we've warned them, etc. So if you're going down that line, I do recommend you always get legal advice. And the employer in this case that we'll talk about now, Baker, probably should have done the same. Imagine a scenario where a supervisor in a sawmill is overseeing a workplace and there's a fire, and you've got an employer who looks at it and believes that the supervisor did not account for the fire well enough, did not address it well enough, may have falsified documents in respect of the fire. Now, this was somebody with 14 years of service who had a clean record, except for recently, in this case, they had switched managers, and the manager had noted and put on file a written warning about performance already. And when the fire occurred and the manager decided that the person hadn't adequately addressed it, there's poor performance. And a fire, of course, significant poor performance, I think we'd all agree, and terminated the employee's employment for cause. Now, the result of this was, when challenged all the way up to the Court of Appeal, the court decided the employer did not have cause to terminate the employee's employment. Why? Well, number one, they didn't investigate properly. Number two, even though there was a fire, it wasn't commensurate with termination for cause, right? Like, it was a serious incident, but didn't rise to the level that somebody should lose their job over it. And number three, and this is a warning to all of us who deal with employees, there were emails showing the new manager actually wanted to terminate this person's employment already without cause. So the judge looking at this said they already wanted this person out of there, and now they're using this as a pretense to do it. So be careful in all of the scenarios that we're dealing with pieces and what we put on paper and emails, because the court may read into the fact that we had an ulterior motive when we terminate someone's employment. Next case, please, or next slide, please. Let's talk to you about theft, and in particular, time theft. Now, adjudicators in courts may have more sympathy for us in time theft cases, especially where we can prove it and especially where we have people who, we place a lot of trust in. This case involving the Yorkton Cooperative Association, it's from 2017, but made its way to the Court of Appeal in Saskatchewan, involved a supervisor committing time theft by falsifying timesheets. She'd say that she'd stay at this location, the store, till 11:30, when in reality they were able to figure out that she was leaving, at times 20 minutes, half an hour early. At the time that they discovered this, they conducted an investigation, the employer, and the employee lied about it, lied about clocking out early, lied about leaving early, and falsifying timesheets. Now, interestingly, an arbitration board found that there was no cause for dismissal, but when that decision got appealed up to the court level and up to the Court of Appeal, the courts were far less sympathetic, especially with somebody who was placed in a place of trust to close the store where others were not directly supervising her necessarily, where she had the power to commit theft and she took advantage of that. They found that, in fact, there was cause and the employer had done a thorough enough job investigating and proved it. And the fact that the employee lied about it during that investigation was an aggravating factor, meaning that they could no longer trust her, and so termination was justified. On to the next slide, please. Let's talk briefly about off-duty conduct and when that might rise to a level to justify cause for dismissal. And I know we've got some questions from you about off-duty conduct. It could be in respect of things people say, whether they put that on social media or they're saying that in a public forum. It could be to do with political events or world events. I've noted that there's some questions around that. And the reality is, before we get into this case, that it will all be very fact dependent on whether or not what that employee is doing has a link really to the employer and to the workplace. Employees, like any one of us, are justified in having personal, private lives and espousing political views, in stating those political views, short of, entering into the realm of hate speech or other activities which might be considered criminal. And they have that right. What they don't have a right to do as our employees is to speak for us unless we allow them to. So this, again, is a good reminder, especially right now where there seems to be a lot of activity of folks making public statements, and that's only going to continue, to have social media or a public expression policy where you make it clear to employees, if you are going to post things on your social media, make sure that you are not linking us to it. Do not put, employee of XYZ. Do not put I speak on behalf of unless we permit you to. So your Facebook, your Instagram, your TikTok, your anything else that people are using these days, maybe with the exception of LinkedIn, which the purpose of which is to show whom you work for, should be scrubbed of any mention of us. You should not be using this for professional purposes, and we should not be connected to it. So that if you go out and make statements which are your own personal views, you make that clear that you're not speaking on behalf of us. And when people do speak on behalf of us without permission and it comes into the workplace, there may be grounds to discipline. There may even be grounds to terminate, depending on what they say. If they're doing things online and on off-duty, on Facebook, which might be harassment, which might be discriminatory towards people in our workplace, that too may be brought into the workplace. That too may be triggering our obligations to look at it and address it. So it really depends on what's happening. It really depends on the expectations we've set with people. Again, policies and making sure people know them and are clear on them are your friend here in case we get into these scenarios. The case you've got up on the screen right now involves the Toronto Police Services Board, where there's an individual placed on an administrative suspension with pay after she's charged with domestic assault. Now, the charges were all withdrawn against this employee, and the employer decided to do its own investigation into the same issue. Ultimately, they decided to terminate the employee's employment for cause for that off-duty incident. And the view of the employer here was the off-duty incident would really bring the Toronto Police Force into disrepute because this was an officer. At the end of the day, when this was brought before an arbitrator, much like I said, the arbitrator said this really has nothing to do with the workplace. It was done, on private time. There's no public pronouncements or announcements linking this person to the Police Services Board. There's no damage or potential damage to the workplace or the employer on this. Therefore, you do not have cause to terminate this person's employment. And ultimately, with no harm or potential harm to the employer, you've got to take the person back. And when this was brought for review before the Ontario courts, the court agreed. So remember, just because somebody's doing something off duty, which you might think is unsavory, it may not represent cause to terminate their employment. Next slide, please.
All right, so I'll be very quick about this one, but basically the next file is about surveillance and time theft. Marc has already addressed time theft a little. Just want to say that, usually this type of case is one of the hardest to have proceed before a tribunal, because usually when we're talking about time theft, it's rare that we will have a clear proof of the actual action that's been taken by the employee that's considered theft. So this case is a file where a call center employee who was providing services from his home actually was dismissed for systematic time theft, the employer having noticed a high number of voluntarily disconnected calls, an alarming number of unanswered calls, as well as a minimal level of sales figures. And what had happened in this scenario was that the employee actually was a call center employee working from the office. From the offices at first, and was given the permission to work from home afterwards. We know that in these scenarios, there's a high degree of trust that is entitled to the employee, and in this scenario, when the employer was informed of the fault or the possible fault, what happened there was the employer decided to proceed with a proper investigation. And this goes back to what I said earlier. When you do a proper, or you proceed with a proper investigation, this sometimes will pay at the trial. And so, despite having direct proof of the fault in this scenario, the arbitrator that heard the case said that the employer actually had done such a good job at documenting the theft that although there was no direct proof of time theft, the use by the employer of the softwares that were available to prove that the employee was disconnecting calls or was basically not taking calls, as well as the charters that could indicate the level of sales prior to working remotely and after working remotely, was strong enough or was sufficient evidence of the time theft, which means that in this scenario, the termination was indeed upheld. Another fact that helped a lot, that shows how good investigating can pay off at the trial, is the fact that the plaintiff, during all the meetings and again at the hearing, refused to admit his fault and basically gave unfounded explanations with respect to technical problems, or with respect to the fact that there was no misconduct at all. So all of these things, taken together, basically led the arbitrator to say that the employer had conducted a sufficient investigation, and the proof was basically there to support the termination. Next slide, please.
Great. So with that, let's give you a few takeaways on this to wrap up the presentation before we'll spend a little bit of time in the Q&A and get through as many questions as we can. If we leave you with nothing to assist you when you are in scenarios where there may be cause for dismissal, whether that is in a unionized environment, whether that's under one of the jurisdictions that requires you to have it in order to terminate an employee's employment, or whether you're in another scenario where you think somebody's conduct has risen to a level where you can let them go without any notice or pay in lieu of notice or anything else, potentially under a contract or the common law or under the civil code, you want to make sure that you're always setting clear expectations, number one, in terms of your policies and process and what your expectations are of your employees. Number two, You want to show that you are addressing issues in a measured manner, that when they come up, you're not knee-jerk reactions. You're not dealing with the case I told you about where you've got, suspicion of a personal vendetta and you want somebody out. And so you think, aha, I've got you, you're out. You're taking the time to go through a process when, you've got small infractions going to larger, going to ongoing, going to addressing the issue. You're not skipping part of that process, including any process that requires an investigation and for you to get the facts right. Because again, if you don't have the facts right, you're done. If you have not done the investigation properly, again, an adjudicator could say, you might be right. You might be right, but you have not proven to me that you've done this properly and landed at your conclusions properly. You want to make sure, again, that you're consistently applying all of your rules and policies, that if you're going to terminate, Joe for being 5 minutes late, and he can't turn around and say, hang on a second, you've let Mary and Susan and Sam be 5 minutes late every day for weeks without, giving anything to them. Why is it me? And condoning that action. So I'm under the assumption that everyone can do it. So make sure you're being consistent in your application, that the discipline you're issuing is proportional, right? Even you saw, even in the case where there was a fire on somebody's watch, which you and I might think that is a huge, huge deal for me as an employer, that you may find that a court says it's not big enough or not proportionate enough in all of the circumstances to terminate somebody's employment for cause. So again, it has to be scenario by scenario looking at it. And if nothing else, and you hear this in absolutely every presentation you get from Fasken, if we're dealing with discipline, if we're headed towards a cause dismissal, please make sure you're documenting it. And I know some of you have asked, even with a verbal warning, should we put something in writing? If you want to do that, absolutely. A verbal warning can show up as a letter to the employee too, with a verbal warning notation on it. Absolutely. Whatever you can do to make sure we've got a clear record of what's happened so that we can paint the picture down the line as to why we've ended up in a just cause termination scenario, and we're using that to defend ourselves against claims that there wasn't just cause. Because if we do not have just cause, as you've heard, and we rely on just cause to terminate somebody, we could end up with having to take someone back in a unionized environment or in any of the jurisdictions where we need to have just cause with back pay or back liability. And if we're in a common law scenario or a contractual scenario and we don't have just cause in some of the provinces, then we could be in a scenario where we need to pay, whether it's notice or pay in lieu. And if we've not done it right, we could find ourselves in scenarios where the court has issued additional damages against us, whether that's aggravated damages or punitive. The courts do not like to see us skipping steps or having improper investigations or having motives which the court thinks are improper for terminating somebody's employment and not paying them anything. So we could have additional liability at stake here if we get it wrong. So everything has to be carefully done. And of course, we'll say, make sure you give us a call before you do anything. But with that said, let's get into some of the Q&A. And we're happy to stay a few extra minutes too to get through some of this. But Rachel, why don't I ask you, if the standard for termination for cause is such a high standard to meet, why don't employers rely instead on terminations without cause? Why not just do that in every scenario?
Well, so there's a couple of things to consider here. So first of all, in the non-unionized context, I'll take that as an example. Employers can terminate employees without cause, subject to the obligation, of course, to pay reasonable notice in lieu of or reasonable pay in lieu of termination, in lieu of notice of termination, subject to any employment contracts. And so if you are in a situation where an employee's performance is not working out, or there have been repeated incidents of unprofessional or unsatisfactory performance, but you as the employer do not feel you've done an investigation, you've taken all of the factors into consideration, and you have decided and determined that termination for cause is not worth the risk, you can absolutely terminate terminate without cause, subject to those obligations. and handle the end of the employment that way. Of course, subject to employers' obligations under human rights legislation to ensure that the termination decision is not connected to any of the protected grounds under that legislation. And that is a topic for a whole other workshop that we provide.
Great. Louis, how about this question? What if management is new, or management has noticed that there's been infractions of policy for a while but hasn't enforced it, but now wants to enforce proper adherence to policy? What should employers think about in those circumstances?
Yeah, so a number of things that you can consider when you're in this situation where there's a new change in leadership and there's a need for cleaning up in the workplace. I think a review of the employer's policies and procedures and an update to those policies and procedures will be important, as well as communicating clearly those expectations to employees. To show that the employer has expectations as to how the workplace is to be in the future. And then, as you indicated in your question, beginning that process of holding employees accountable to those expectations, to those policies, including through the use of progressive discipline, trainings, things like that. All things that outside counsel and us lawyers at Fasken can help you deal with when you're trying to enact a workplace culture shift at your organization.
Okay. How about this, Louis? In a unionized environment, can you speak to us just very briefly about what we can use prior discipline that has been sunset for, if anything?
Can you just repeat this, Mark? I didn't get it. There was a problem with the sound.
Sure. In a unionized environment, which is not the same as a non-union, you could have obligations in your collective agreement, basically to wipe clean a discipline record after an amount of time. So, what happens if that occurs with an employee? Do you start from scratch on progressive discipline?
Well, actually, unfortunately, in Quebec, this will be the case depending on certain exceptions, which means that these types of clauses in Quebec that are not too often included in the agreements, but sometimes, unions have a strong power during the negotiations, and we'll try to have these clauses put in there. What we will want to do in these scenarios is make sure that if we feel like an employee has problems with respect to discipline, we will want to make sure that we're not letting anything slip. Because after a certain time, there will be, basically the measures will be completely erased from the file. And unless we can prove that there's, let's say, a scheme from the employee, or there's a specific avoidance where we would try to submit in proof at the hearing that there was, a pattern, unless we have this, we will have to resort to, starting again with the progressive discipline, or, invoking that there was a serious enough fault to basically proceed immediately with determination. So, in Quebec, a great question there, Mark. There might be a problem if in your collective agreement you have this type of clause, which should always be considered before conducting the investigation.
Great. And of course, in a non-union scenario, any discipline doesn't disappear. So if we're talking about progressive discipline, it can stay on there for years and years and years. That being said, if somebody has discipline that is now 5 years old and it was a verbal warning, then the next little infraction, we may not be jumping, immediately to discipline, even if we give a final warning, for example, and years have passed and there is another infraction. We may not be in a scenario where we will be able to prove to a judge or adjudicator we had just cause because of the next infraction. Everything has to be taken into account. Prior discipline, of course, can be taken into account, but so too must be the employee's clean record for the time in between discipline in a non-unionized environment. Okay, what do we think about this scenario? And we've got a question here about what if an employee provides a seemingly falsified medical certificate? What do we think we should do here? Rachel, what do you think on that?
I think as Louis impressed upon all of us in the last hour, the important thing here is to thoroughly investigate this quote unquote seemingly falsified medical record. And because the allegation of dishonesty and of forging a medical document, it's quite a serious allegation. You're going to want to make sure that you do your due diligence in following up with the employee and following up with their healthcare practitioner to verify the authenticity of the document and provide them with an opportunity to address that allegation before you take any disciplinary measures.
Great. Louis, maybe you can speak a bit about what does a tribunal or court read into in terms of the termination letter? Can we be held to account in what we put down in writing when we terminate someone's employment?
Absolutely. This will be especially true, as I said before, if you're in a unionized environment, because sometimes the collective agreement will state, precisely what you have to have included in the letter. So for these environments, I would say you will be absolutely held upon what's been included in the letter. And if you want to provide additional proof of additional faults, there might be an objection at the hearing regarding this. With respect to non-unionized environments, although it's a bit different, it's still kind of the same, meaning that you don't necessarily have to put as much in the letter as you would in a unionized environment. But as I said before, the employee still has to be informed at the meeting and in writing of what, was the basis or the foundation of the decision by the employer. So once this has been disputed, there will be, the decider, the adjudicator will hold the employer accountable of what was the basis or the foundation for the decision at the time. Also, if I may come back to one of the questions that you addressed, I believe, at the beginning of the presentation, in Quebec, sometimes there is a strategy that we will use if we learn additional facts during the preparation for the file. So let's say you've terminated an employee for a breach, let's say of trust because of certain actions that were taken. And once you're preparing the file, you learn that there was some additional fraud. In Quebec, sometimes we will send a second letter of termination stating that although we feel like we had enough at the time, should the decider annul the measure, we would still have imposed a termination because of new and additional facts that we have learned throughout the investigation after, proceeding with the measures. I just wanted to say for Quebec, this is an option that, employers might want to consider depending on the scenario.
Great. Maybe we'll take one or two more questions. I'll answer one here quickly. There's a question about if we're in a scenario where an investigation is warranted and we have to look at investigating, what would be considered a timely investigation? And I'm going to give you a classic lawyer answer, really trick and treat here. It really depends on the scenario. So if we're in a scenario that requires an immediate answer, or our policies may set out a timeline, we really should be complying with that timeline. We can be held, of course, to our own policies. So you don't want to be in a scenario where we've terminated for somebody for cause, and our policy says our investigation would start, any investigation start within 10 days, and we've started our investigation 90 days later. That being said, there are certain things which may slow down an investigation, complexity, whether we need to go get an external investigator if we're in that type of investigation scenario that might, excuse a delay, whether somebody who's important to the investigation is off on a medical leave and goes off. I know we all are used to those scenarios where, we may be holding someone to account on what they've done, and we get that medical note saying they've got to be off for a period of time. Of course, when that happens, there may be opportunities to interview them or participate in the investigation while they are off on a medical leave. If a union's involved, you may want to have the union involved in setting that up. But make sure that everything is tailored to the scenario. What we don't want ever is for an investigation to drag on forever and ever. And We certainly don't want an investigation to drag on where we think we may have cause to terminate somebody's employment. We continue to let them work. And I've seen this, the investigation takes months and somebody is continuing to work and we finally conclude it and we say, hey, we've got cause to terminate your employment. Because then an adjudicator is going to look at us sideways and say, if you thought that there was something that bad happening and you still let them work and you still let them do this and you expose yourself to risk, I'm not buying the fact that you thought that this was cause for termination and that you were really worried about them continuing to affect your operations. So, we got to be prudent here and wrap it up as soon as we can, without cutting corners. So everything is going to be fact specific. One last thing, because I know, and I'll readdress this for folks, because it's been questioned a bit. We've got some questions about folks putting out on social media or on their own accounts whether or not their views on the situation in Israel and the Palestinian territories, and whether or not somebody expressing their views on this may amount to cause. I think what you need to again remember is what I said earlier about use of social media and off-duty conduct. Again, folks have a right to express their opinions. As an employer, you certainly have a right to express your own internal corporate opinions and expectations of folks in the workplace and getting along. We can all have different opinions and positions on very difficult subject matter and still, continue to work together. If somebody, though, is out there in public speaking on behalf of the company or doing things which may amount to harassment in between work colleagues, that may be a different scenario, but everything is fact specific. So someone declaring their support or their position, which again, as private citizens, they're entitled to do, it may not be grounds for termination, or maybe. Let's look at the facts and what's happening. Okay. I know that we have got through quite a few questions. There are some more. I apologize that we've run out of time and we'll give you back your day. But we certainly have enjoyed spending our Halloween with you. Before we all let you go, we want to remind you that our next event will be on November the 14th. It's a general discussion on labor law. Invitations are going to be circulated shortly, so please watch your inbox and hope you'll join us. And from myself, from Louis, from everyone on the team here behind the scenes putting on these, thank you so much for participating in this Fasken Institute. Look us up at fasken.com for some of our previous sessions and future sessions, and have a very, very happy Halloween.